Welcome to the Estate Professionals Mastermind podcast, built for real estate professionals that want to work less, earn more, and make an impact in their community. For information on how you can become part of the estate professionals community, visit probatemastery.com. Welcome in. This is the weekly Probate Mastery coaching session. It's the Estate Professionals Mastermind kind of live call. If you guys have never been here, we're here to answer your probate or estate administration related questions. That could be advanced, how do I get started? Or it could be advanced, hey, I've got this weird deal that I'm trying to structure or this weird situation. We could help with that. Or it could be super basic. I don't even know how to get started. So this is your opportunity, whether you're in probate mastery or aren't in probate mastery, it doesn't matter. This is your opportunity every single week to ask questions that you might have. It's usually the best way to get quick responses. It's not just me on here. There's a bunch of other certified probate experts and people that are rather seasoned that can also answer some of the questions that you guys have. So with that said, if anyone does have a question or has a topic that you'd like to discuss, you can go down and just raise your hand, just like Garlinda just did. So to do that, click the react button at the bottom of your screen, and there's going to be a bar that says raise your hand. And I lost Garlinda. Where did you go? Oh, there you go. Hey.
Well, I didn't want to, I'm driving and I had to lower my hand before I ended up a hood ornament. So I was like, let me lower it while I can. Yeah. So happy Monday, guys. I had a quick question. So husband passed away. The wife is it the right word? Predeceased him. She died 2 years ago.
Mm-hmm.
So the husband just passed away and the job paid for the husband's funeral. The wife was the only beneficiary for his insurance. So the funeral home called my client and said, hey, we have a check here for your mom, but the mom's passed away. The husband just died. Who gets the check?
How much is the check?
Like $20,000.
Okay. The check, I believe, is going to need to go through probate. Have they already
Really?
the mom's estate?
So I asked that question too. So no, the husband didn't probate the mom's estate.
Okay. And that's been
now
how
the
long
son
ago?
is probating the dad's estate. 2 years.
2 years. You're in Georgia?
North Carolina.
North Carolina. Oh,
I'm with you. How do you not know? We're together in the best state.
I know that. Yeah. Okay. Has it been 2 years and days, or has it been a year and 11 months?
2 years and days.
2 years and days. Okay. Fortunately, and this is not set in stone because I was just going through a similar thing with different assets. 2 years in North Carolina, 2 years really for across the country is the creditor period. So after 2 years, creditors really can't attach estates. And I know that's at least the case in North Carolina. So it's probably going to need to go through a simple probate process, a simplified probate process in North Carolina. I would call the clerk of the court and say, hey, here are the heirs. Did the mom have a will or no will?
No will and 3 sons.
Okay. I would start by going to the clerk's office and telling them what the situation is and finding out if they want you to submit a probate application or an administration application. North Carolina, and this is a good little spin-off for everyone, specifically North Carolina, but a lot of other states operate this way as well. When there's not a will, you technically are applying for estate administration and not probate. So I would call and just say, hey, it looks like we've got an estate that needs to be administered. There was not a will, and the only assets that didn't immediately transfer to the spouse were this check. Okay. As a matter of fact, this check just came up. do we need to probate it? And the courthouse is probably going to tell you that there's a way to skip it. Okay. But technically, I think you need to include them and talk to the court and make sure that they don't want that probated. I think that you're going to have to do some kind of a simplified probate process on the check.
Okay, and then this may be a dumb question on my part, but if she's just, and so I'll tell him to do that. So now she's not here, the dad's not here. How does the check then get put in that administrator's name?
It's going to need to go into the estate's name, for the mom.
Got it.
Into the estate.
Okay.
Now, fortunately, it's if it's 20,000, then it's probably also going to
A small
qualify
estate.
for the small estate.
I'm trying to practice probate mastery in my mind. Okay, go ahead.
Yeah, no, it's probably exactly what you just said. I think it's probably going to qualify for the small estate.
Okay.
So, but small estates, you still have to go to the court. You still have to apply for the small estate exemption. So I don't see any way of doing this where you're not going to be calling the clerk's office and filling some paperwork out.
Okay. Thank you.
Yeah. Hopefully they just tell you, oh, fill this form out. It's small estate, or fill this form out. We'll run it under the husband's probate. Hopefully. I don't think so, though. I think that you're going to have to run something under the deceased wife, and then more than likely it's going to be small estate, or it's going to be able to skip the creditor period and be a simplified probate.
Okay, and then my last question, not to hog the call, reference one-on-one coaching. When we sign up for that, is that with someone on the team? Like, how does that work?
If you're going onto the website and you're booking a discovery call, that's going to be someone on the team. And then if you want to book private coaching with me, they'll be able to get you booked for any private or group coaching that I have. But normally, if you go through the website to land a session, you're going to be with someone on our team, and they're called success managers. They're usually peers that are you'll be able to ask questions of, and if it's something that they haven't handled, they'll usually escalate it to me.
Okay, good deal. Thank you.
Good. With all that said, and kind of segueing into a question that was chatted in, and I think that this is going to apply to Garlinda as well. I want to talk to you about the situation that I ran into a little over a week ago. I had someone whose mother had passed away 4 years ago. So 4 years. It was outside of the 2-year window in North Carolina, and there was no will. So a lot of identical things to what Garlinda you were just describing. No will, passed away. The only asset was a house. So that's and I think that there was a bank account with $3,000, but the house is more than $50,000, or for a single person, $25,000, which is the smallest state limit. So there's all kinds of conflicting information online, and funny thing is, there's all kinds of conflicting information between attorneys as well. So just because I wanted to use it as an excuse to build some better relationships with some attorneys that I knew and attorneys that I didn't know, I went ahead and picked the phone up and started calling attorneys, both attorneys that I knew and that I didn't know. And oddly, every single attorney gave me different information on what to do with the house. So there's a 2-year creditor period in North Carolina, and this is going to apply for the majority of you guys. Please talk to attorneys and double check. But there's a 2-year creditor period where if you're outside of two years, creditors have usually lost their opportunity to come after assets. Okay. Usually. So she's got a house that's free and clear. I called a bunch of attorneys. One attorney basically told me that because it's a house, and in North Carolina, houses often pass outside of probate, and because it's been more than 2 years, that we would be able to go and change title with the clerk's office, which it turns out to be true. I called a couple of clerks and they confirmed, and I called one clerk that said, no, you can't do it that way. So it's really interesting because I was just using it as an excuse to reach out and build my network and talk to clerks and get people to know me. It's really interesting that even in the court offices, they follow different procedures as well. So one clerk said, no, that's not the way. You need to apply for a simplified probate. And two clerks said, you're absolutely right. We can just change the title from the house to the heirs' names. So it basically, the title changes from Mary Smith, if that was her name, I don't know, I can't remember her name, to the heirs of Mary Smith. And it's as simple as that. Now the heirs can go sell their house, but it's listed as the heirs of. And that's because it's been more than 2 years. And in North Carolina, they kind of have a simplified process for keeping real estate out of probate. So I want you guys to look at that in your state. This is a great opportunity for everyone here when you find out a situation like this, or when you're dealing a situation like this, even if you know the answer or think you know the answer, because I thought I knew the answer, to call attorneys and call the courthouses. Really golden opportunity to call the courthouses. Now, it's also a golden opportunity to come here and ask the question so that we can work through it together. But a lot of times the answer that I give you isn't, hey, here's the rule. This is exactly what you're dealing with. Sometimes the answer I'll give you is, hey, let's call some attorneys. Let's also call the courthouse. Here's how I'm going to kind of work through the process of finding an answer. And I would work through the process, Garlinda, of finding the answer by calling the clerk's office and also calling attorneys. And we need attorneys, guys. Someone else just chatted in that they wanted to talk about building attorney relationships. No better way to build attorney relationships than call and say, hey, I've got this situation. I'm in real estate. We don't know each other. I've realized that I need a good relationship with an attorney that handles work like this. Do you guys do probate? And of course, they're going to say yes. And then should I call you with situations like this? Are you interested in working referrals if I run into things like this in the future? What are they going to say? No? Of course, they're going to say yes. And then I would just say to the attorneys that I talk to, is there a way I can run the scenario by you and find out if this is something that you'd like to be involved with? And that's exactly what I said to these attorneys. And I probably talked to 9 attorneys. Hopefully none of them are on this call. Is there a way I can run this scenario by you and find out if it's a client that you might be interested in working with? And all of them, in my case, just gave me advice. And then I set follow-ups with all of them. I took one of them to a hockey game on Sunday. So, by the way, I took them to the Canes and Kings hockey game, Bill, and go Canes, we won in overtime. So really good opportunity to take these and build relationships, even with attorneys that you don't currently know. I went from having an attorney that I didn't know to having an attorney that I knew and took to a hockey game, all because a client called me with a question that I didn't know the answer to. Okay, so please consider your opportunities to go build your network. And when you run into awkward, unusual situations where you don't know the answer, you think you do, but you might be wrong, never be afraid to use it to call some of the network people in your people that you want to put into your network. And that's financial advisors, accountants, contractors, attorneys, so many different people that you could use these opportunities as an excuse to call and build a relationship with. Hey, Michael White. What's up? Another North Carolinian. This is a North Carolina call.
Yeah. Hey, Bruce.
What's up?
So, no, not much. Last week I had a coffee meeting with an attorney, and we were talking about the 2-year statute limitation you were talking about a minute ago, and, selling property after 2 years and that kind of thing.
Mm-hmm.
And she said that what she sees a lot is that the title companies are requiring these people to go through probate just to make sure the title is clear. That even though statute does not require that, that it go through probate, that it is a title company requirement. Mm-hmm. So she finds it very frustrating to have to do what the title company wants to do. Yeah. So just keep that in mind.
Absolutely. I got that answer from 2 of the attorneys that I talked to as well. And of course, this can't be one of those situations where we say, "Hey, I didn't get the answer I want, so I'm just going to go and talk to a different attorney until I get the answer that I want." But it's still really interesting to hear the different legal opinions as well, from one attorney to the other and one practice to the other. The attorney that I ended up talking to and connecting the client with said that he sees title issues all the time, and that there's a pretty simple way to clear up the title and make it marketable. I can't remember exactly what he said, but it's a really important thing to point out that you had a meeting with an attorney that said, "Hey, you might not have a problem. Maybe from a court standpoint, you can skip probate, but title might require you to go through probate." Another attorney pops up and says, "Hey, I've got a way to get around that." So, Michael, I would use this as a chance to go build some relationships with new attorneys and find out who has these weird, unique ways of getting around it. Not because you're going to use exclusively the attorney that finds a way around the marketable title, but because you want different attorneys that have different specialties. And I'll have a relationship with all of them. Even if somebody gave me a lousy answer, I still want that relationship. But that's an important thing that you brought up, because that's specifically something that I talked about with a few of the attorneys that I called. Lakeisha.
Hey, Bruce, also in North Carolina.
Oh my goodness! Wow, amazing.
I have
promise,
an interest.
for those
I
not
have an
in North
interesting
Carolina,
situation. I'm sorry.
for those not in North Carolina, this is not an only North Carolina call, but go for it.
So I have a situation last year, late last year. A family came to me about a property that they wanted to sell. And since that time, the father died 4 years ago. And since that time, one of the heirs died. That heir lives in Georgia. And he has descendants. So they're going to open up probate in Georgia. They're going to open up an ancillary state in North Carolina for the interest of the deceased child in Georgia. My question is, I'm thinking I cannot list that property until that happens, and the North Carolina attorney has his letters to be able to sign. That's correct. Yeah. Okay.
That's correct. Yeah. Any follow-ups on that, or should I go into clarification for those that don't know what we're talking about? Any follow-up questions?
Oh, no, I don't have a follow-up.
Okay.
I think you answered I thought that to be the case. They were ready to move, but they should have sold when the brother was still alive, but they waited and he passed. So I'm waiting for that process.
So considering it's North Carolina, there could potentially be a way to not do that, because real estate, if there is a will, real estate often does not need to go through a probate process. Okay. But this is kind of a hairy situation, so I would wait until I had letters of authority, letters testamentary on for everybody. So for those that don't know, when someone passes away, you need to open probate in the state where they lived. Okay. If they have real estate, specifically real estate out of state, you need to open an ancillary probate that deals specifically with the real estate and only the real estate. They could have a car title. It doesn't need a secondary ancillary probate. But if there's real estate, it needs another probate in the state where the real estate was. So you may end up running two different probates. And in this case, for Lakeisha, the property is in North Carolina. Brother that passed away lives in Georgia. He's going to do all the probate stuff in Georgia. And then North Carolina is basically going to piggyback on the Georgia process, but it's going to be for the house only. Unfortunately, you're gonna need the letters testamentary. Fortunately, that shouldn't take very long before you can put the house up. All right, good. Back to Garlinda. And I already see at least one other hand from North Carolina, so Maybe it is North
We
Carolina.
rock. North
Yeah.
Carolina, the best state. I'm telling you. Okay, I appreciated Mike's reply because I had not thought about title. So I appreciate him for sharing that.
Yeah.
This is a different client. So I had a client that was referred to me by from probate referral, and she thought she could just take over a property that her husband owned because he passed away and his then ex-wife passed away. So it turns out that they had 5 children, and the first wife had 5 children. She has 3. And now she's thinking that, and I just want you to confirm if that's possibly the case. That means that there's 9 heirs to this property. There was, right? Because there's no will. And the ex-wife, even though she passed away, wouldn't she have gotten entirety rights as well?
Know.
And then
the deed say.
Say it again.
What's
the deed? He did a quit claim deed that added the second wife. And it said unmarried, but they were married.
But they were married.
Mm-hmm.
Oh.
I think he quit claim deeded it at the time when they were just dating and, doing whatever they were doing. And then she died. So when she died, he remarried the first wife. And so I told her, and I don't know if I told her right, that would make them tenants in common. Because she also is a wife. Sound like he just needs to get himself together. So now there's this property. The property's going into foreclosure. It's worth $130,000. They only owe $61,000, and she's trying to figure out what to do with the 5 heirs to the deceased wife.
My goodness. Okay.
We can't make this stuff up.
let me. I'm gonna do my best to repeat what I think is happening. Okay.
Okay.
So. He quit claim to the second wife who is deceased. Okay. Wife number 1 is not on the deed at all. I think that wife number 2, who's passed away, probably her heirs get half of the property and his heirs get half of the property. So her kids, deceased wife's kids, probably get half of the property, and existing wife gets the other half, but she's probably going to have to split the other half with her kids. So one set of family members gets one half, and another set of family members gets another half, and no will. So it's going to need to run through intestacy laws in North Carolina. And probably be subject to an upset bid period. So that's going to be a hairy one.
It sounds very hairy and sticky, like that piece of candy at the bottom of your grandma's pocketbook.
Yes.
So
yes, very much.
So let me ask you this, and then I'll shut up. So could she do a petitioner sale? I don't know if I'm saying it right, but like when my father-in-law passed away, he became a tenant in common with my mother-in-law's sister and brother, and he did a petitioner sale. So it forced the sale of their mother's property. Could she do that?
Yeah, but she's still going to be stuck. Well, doing a petitioner sale is basically going to be there's going to be
I get what you're saying, because she don't. Yeah, they still need signatures. Yeah,
it still needs signatures, and it's not like, hey, I'm going to go force a petitioner sale and everyone's going to agree with it and there's not going to be any fight. There's sometimes a fight if any other family members don't want to do it. Now you can force it, but it's not like, oh man, you just did a petitioner sale. I guess I'm just going to lay down. If people are going to fight, they're going to fight. So can she do that? Yes, she can do that, but you need to make sure that she actually has any kind of claim on the property at all. I think she has a claim. So phenomenal excuse to bring an attorney into the fold. another really good excuse. This one is hairy. Petitioner sale would probably be the last place that I would go, but if she wants to sell and everybody else is dragging their feet, absolutely, I would I
Well,
would.
it's going to foreclosure, and she doesn't know where the 5 kids are to the first wife. So it's almost like she may just have to let it go to foreclosure.
There's a lot of equity there.
You think?
I would go through the skip trace process of hunting everyone down. They may not
Okay.
even they may not even know what's going on or know that they have some equity. Now that equity is going to be chopped up a lot of different ways,
Mm-hmm.
but
Mm-hmm.
they might not even know that they have any equity in a property.
Okay. Good deal.
And would anyone handle it a different way? And if I've got a bunch of hands up, so I'm going to go to my other folks. If somebody is thinking of handling Garlinda's situation in a different way, pop your hand up and bring it up when you come up. Let's go to Chad first.
Good afternoon, Bruce. How are you?
Hey, great. How are you?
All right. I have a scenario with a probate deal where the son received the right to sell the property. The property was put into his name as of October. He signed a listing agreement, but the agent never put the property up on the market at all. He's trying to cancel the listing agreement to sign with me, but there is a $1,000 cancellation fee that they're not willing to pay. How do you think, being that she never put the property up at all, I feel it's something that we could lean into, but could you give me some insight as to how you'd approach it?
Are you an investor or realtor? Do you have a license? Do you have a license?
Yeah, I have a license. So I'll be doing this this one's going to be as a realtor.
Okay. Considering that you have a license, I would absolutely talk to an attorney. If I think that this is a good opportunity, I would talk to an attorney regardless. But being that you have a license, I think it's even more important that you talk to an attorney. You don't want to be perceived as having as going around the sign. And interfering with another agent's relationship. I would be curious to see if their listing agreement says anything about the property being a pocket listing. If it's a pocket listing, someone's going to need to pay that cancellation fee unless the other agent's really nice. If the listing agreement that they have with the other agent says, hey, we're going to market the property, we're going to put it on the MLS and it's not up there, then my non-legal advice is the other agent has violated the terms of the listing, and it should be able to be terminated without no recourse that the other agent would have. But I don't know what the listing agreement says. If it's pocket listing, then they need to talk to an attorney or hope that the listing agent's really nice and a good mood that day.
Well, I'm sorry to break up all of the North Carolina love, but here in Florida, I don't think we're allowed to have pocket listings. So I don't think that's.
It doesn't mean that they didn't do it. Okay.
Gotcha.
Pocket listings, man, I don't know. I haven't heard anything about. There's a lot of brokerages and the Association of Realtors that may not like pocket listings, but I'm not sure if states say no pocket listings or not. Anybody else in Florida that can speak to that? It may not be a pocket listing, but it might say, hey, we're going to advertise it not in the MLS.
Okay.
So MLS says no. So the Garlinda, that's North Carolina. A lot of times the MLS will say no, but who's to say if that agent is in the MLS? So I would just be looking, I would have the seller look to see if the agent's violating the terms of their contract. You can look at it, but be careful about giving advice. I would have them look to see if the agent's violating any terms. If they're violating terms, then it's going to be much easier for them to get out of without a cancellation fee. It sounds like they want to cancel anyway. If you're going to get a good deal out of it, maybe you reduce your commission or do something to help them get out of there. I hate to play with people's money though, so do what you want. I would help them cancel if they definitely want it out and the other agent wouldn't play ball though.
Yeah, well, they had 3 days to put it on the market, and that was from October. They haven't done it, so that would be a violation of.
How is that possible, man?
It's
Okay.
crazy. I don't, and yeah, and she didn't show it to anybody. And it's like, I don't understand what she was doing all of this time.
You sure they didn't put it in a different MLS?
Yeah, it's not in the MLS. It's not online at all.
Okay.
It's nowhere to be
Yeah,
found.
sounds like the other agent violated their listing agreement. So should be fairly easy to get out because from what it sounds like is the agent was the first one in violation of the agreement.
Yeah, exactly. All right. Cool.
Send them to an attorney though.
Okay, I will.
Don't try to give them the legal advice. We can be 99.9% certain that this is the answer. But I don't want you getting in trouble by saying, "Oh yeah, you can cancel the listing."
Okay.
Yeah. Hey guys, I'm butting in here with a quick ask. If you're getting value out of this coaching today, I want to invite you to check out my Probate Mastery trainings over at www.probatemastery.com. Probate Mastery is for you if you're an agent or an investor that wants to work with motivated sellers that have inherited real estate that they don't need and in many cases can't afford. These sellers are more appreciative, willing to trust your expertise, and less likely to nickel and dime you over commission or price. Why is that? They're often in the middle of a complex probate or an estate administration process, and this means that real estate is very often a burden on them and they simply need the help. Inside of Probate Mastery, I teach you exactly where to source your leads, how to establish value, and offer your service in a way that quickly makes you, as the professional, your market's expert in the probate space. If you want to know a little bit more, go over to www.probatemastery.com. Hope to see you guys inside of the community. Thanks.
Well, I have one more question, if that's okay.
Yeah.
All right. I have another case that I'm working, and the heirs, one of them is locked up, and the other one is they can't find him. Like he has mental issues, and they can't, the siblings can't find him. So I don't know what to do.
Have you done a deep dive skip trace on the heir that they can't find? Because what does can't find mean?
Can't find meaning that he's on the streets, like he's like mentally ill, and he's been in some housing, and then he's on the street. So
this would be where I would probably go after a petitioner sale, like Garlinda brought up earlier, and maybe force the sale. If the court gets involved, they might be able to force a power of attorney. There's gotta be. Has anyone dealt with that before? Now I'm thinking out loud at this point. I feel like there's some kind of a forced sale that could possibly happen if someone is legitimately can't be found. They're on the streets. As anybody wave at me if you've dealt with that before and are like, Bruce, you're crazy. Matthew Price, what do you know?
Money tends to find family when they don't want to be found.
Yeah, exactly. Money tends to find family. They did a for sale down here in Harnett County, and it was extremely expensive to do. So it wiped out all the equity of the property. But they did manage to find him because he came out from underneath that rock.
Yeah, I just helped a lady that did a sex change and didn't have an ID in Texas, and she was homeless in California, but male originally. So
How come you get all the lucky ones, Dave?
I don't know. That took a year, almost to the day, to finish.
Could they get a private investigator to go try to find somebody? That's a possibility. If people really want to sell, you could get a private investigator to hunt somebody down. Most people don't really know how to skip trace. So if it's the normal family and they can't find someone, a lot of times it's because they don't know that there are tools to use. Now, if somebody does not have a residence, probably going to be a little bit more difficult, but not 100% impossible. I would. Has anyone gone through the courts to solve an issue like this? That's what I'd be curious about. Has anyone gone through the courts? You guys are bringing some doozies today. I don't have the best answers for.
Okay, well, the hard to find homeless brother is the easier part of the equation because She also has a sister that lives in the house that the property is in foreclosure with a USDA loan, and the sister doesn't want to sell. But so, you know what? I'm going to keep on working this one, and I'm going to give you a testimonial. We'll talk about it when I get it wrapped up. But so just for clarity, with the sister that lives in the house that doesn't want to sell, all she would need is notification, right? That the probate is being filed, right?
Yeah, she will. I can't remember. Did you say there was a will or no will?
No will.
No will. That makes it a little trickier, a little bit, not impossible, because when there's not a will, it usually requires everyone to sign. But the court has ways of getting involved in forcing things. So go ahead and apply for probate, explain it to the judge. I would absolutely get an attorney. Is there enough equity in the potential deal to get an attorney involved?
Yes.
Yeah. Okay. Get an attorney involved, and so use this to reach out to a few attorneys. Maybe try to find someone that'll give just general guidance first, and sort of say, hey, this is what I would do, and then I would be happy to do it, or I don't want to do it. And that's what I did with these attorneys that I was calling before, is saying, hey, looking for an attorney. This is the situation. Can I describe it to you, and then tell me if you are interested in working a case like this. And I got some great free advice and guidance from attorneys that said, no, I don't want to do this, but here's what you should do, which is phenomenal. So I would call a handful of attorneys and kind of run it by them and find out if they'd be interested in helping.
Okay. Great. Thank you so much.
Did you say it was under foreclosure as well?
Yes, it was.
You probably want to get some kind of you'd probably want to hurry up with the attorney, like Bruce says, and then try to throw a blanket on that foreclosure, because that's going to take precedence over the probate.
True. Yep.
You said throw a blanket?
Yeah, stop the sale by the bank.
Okay. Gotcha.
Hey,
All right.
Chad. Chad, you're here in Florida, is that right?
Yes, I'm in Florida.
We have a probate attorney here in Florida that loves deals like this.
Is it Al by any chance?
Yes, Bruce, it is.
Yep. Okay. Yeah, get with Al Nicoletti. I wish if you have his contact information, drop it in chat. But
I will do that, sure.
Absolutely. Al Nicoletti does love deals like this.
Yes.
Yeah, I have Al's number.
Oh, you do? Okay.
You do? You have it? Okay.
Everybody knows Al.
Thank you. Yeah. All right, awesome. Thank you so much. I appreciate everyone's help. Thank you, Bruce.
Thanks, Chad. Appreciate it. Hey, Mike, you still there?
Yeah. How you doing, Bruce?
Good. Someone else.
I've got a couple of questions that might be a little simpler, I hope, than what you've been fielding this afternoon.
I hope so. Maybe I'm just kind of snake bit and I'm not remembering any answers to anything, though.
On your VA that's making your phone calls, do they ever get flagged for spam? Or are you making that many calls?
All the time. Was your next question going to be, how can I keep from getting flagged as spam?
Are you A2P compliant? Did you have to register with the phone companies, or is that just for mass texting?
That's for mass texting. Being compliant with the 10 DLC registration will help you keep from getting flagged as spam, but it's not foolproof. So if you're going to text from a number, especially if it's a voice over IP line, you need to register 10 DLC, which is going to make you A2B compliant. At least it's half of the process. And it'll help your numbers keep from getting flagged, but you've got to really practice great phone management. You have to have really good phone management skill, which I've been dealing with this today, because our numbers are getting flagged as spam in record time, in like a day or two of using numbers. Wow. So in the past, the rule has been that if you frequently make more than 50 outbound dials in a day, you're going to get flagged as spam eventually. So we just went out and got enough phone numbers to where no phone number is dialing more than about 30 or 40 dials in a day, and that a year ago would have done the trick. It doesn't do the trick now. The other thing that we were doing, and most of you guys have heard me say this, we were calling people that didn't answer the phone. We were calling them three times in the same day. As of today, we're going to stop doing that because the phone carriers are also looking at unanswered calls without voicemails, personalized voicemails, and they're looking at the percentage of unanswered calls. So if somebody didn't answer my phone twice today and I do a third call, the percentages of them answering are pretty low. So overall, our percentages of answers are pretty small on a round of calls. Now, over the course of a month, I might get 50 or 60% of my leads to answer the phone, but that's on 20, 25 calls. So the carriers look and they go, only 4% of your calls go answered, and you're making 30 or 40 calls in a day. You're obviously selling something. So the carriers just have AI that's set up in their systems that's monitoring call habits, and they're flagging you really fast. So there's a couple of ways that it would seem that we can protect our numbers a little bit more. Is number one, not to make more than about 15 dials per number. Number
15
two,
or 50?
15.
Okay.
Number two, leave voice messages, personalized voice messages, not a voice drop. Voice drop is better than no message at all. I don't like these rules, guys. I'm not happy about the news that I'm giving you, but leave voice messages. Change phone numbers. If you're going to make more than about 15 dials in a day, change phone numbers and make sure that you're not doing those 15 calls back to back to back to back to back. So another thing is if you're going to call someone, call them from the same number tomorrow. So we're going to quit doing 3 dials to the same lead every day. I don't like it. Okay. I want to do 3 dials to the same lead. I want them to go, man, I've missed this call 3 times today. It must be important. Unfortunately, the carriers are on to us and are flagging spam. And then the last thing that we're changing is we're actually registering the number, and I got to look at the name of the registration. It's not the 10 DLC, which allows you to text. It is, and I'm going to give it to you guys in 1 second. It is, nope, I'm not going to give it to you. It's registering. You know how if somebody calls you, you're actually registering with the carriers and you're saying, this is my company name. If you guys ever get calls from the dentist or the doctor's office, it shows up healthcare. So it's the same thing. It shows up with your organization name, and that the carrier views it as a little bit more legitimate and is less likely to push you into the spam flag or spam flag you. I'm not saying they're not going to spam flag you, but they're a little bit less likely.
Okay.
All right. I don't love the news that I'm giving you, but we're getting numbers flagged as spam that never would have been flagged before. So it's getting tight.
Okay. I got one more question, Bruce.
Mm-hmm.
I've been doing a little research, and it looks like the only way I can really get paid any significant amount on a house, I would have to be a principal in the deal. So if I had an option, say, to buy a house in the next 90 days, could I put that into that system you were talking about last week?
Yeah, there is a way. I was talking to our to an attorney that helped build the system, not a North Carolina attorney, but yes, there is a way to put it in and actually wholesale. I don't think that you, by principle, are you kind of saying that you wouldn't wholesale? Is that what you're saying?
No, I would either have a contract on to to purchase it just like a
Oh, yeah.
wholesale contract, or I would
Yeah.
have an option to purchase it.
Yep. Yep. Yes, you could put it through my system. It gets a little bit hairy for wholesalers to put it in my system, but it's absolutely happening. The reason that it gets a little bit hairy is not every single one of the institutional buyers that are in there will accept assignments. That's the only reason that it gets a little funky, because you're going to get 5, 10, 15 offers, offer proposals, let's say that. And then some of them are going to come through, and if they see a wholesale assignment, they'll just back out because their internal rules just don't let them take assignments. But there are several of them that are doing assignments as well, so it could work.
Okay, if my option contract so permitted, could I list it on the MLS?
Yeah, I mean, you'd have to have an agent that listed it on the MLS, but yes, absolutely, happens all the time.
And that I could partner with the agent through that mechanism.
Yep,
Okay. All right. Thanks, Bruce.
definitely. Thanks, Mike. Helena.
It's Helena. How are you?
Helena. Yeah, good. How are you?
How's everyone? I'm calling from Maryland.
Oh, man, thank God. Somebody from another state.
I just wanted to know, how do you do a skip trace on a missing person?
Yeah, there are a bunch of platforms. So the ones that I like are Ben Verified, BEEN Verified, Propelio, PROPELIO, Skip Genie. Somebody just chatted in Skip Genie. Probably the best one that I've found is IDI Core. IDI Core. Somebody that uses IDI, tell me if that's wrong. Forewarn. I can't believe I didn't say Forewarn. Forewarn is typically free through a lot of MLSs. IDI Core is the other one, and I just put it in chat. IDI, phenomenal, expensive. So IDI, if you're just doing one, it's like $1.50. If you're doing 1,000, it's $1.50 times 1,000. So it gets pretty expensive to run through IDI Core, but they have, in my opinion, from the ones I've used, the best accuracy. You've got White Pages, yeah, White Pages. Most of the ones, there's PropStream. There's just so many that are out there, but I like Forewarn if it's through the MLS and you have it. Otherwise, my personal favorites are Ben Verified and Propelio. And by the way, Propelio uses Skip Genie, so might as well just go to Skip Genie.
Okay. Thank you.
Sorry to just drop a million skip tracers on you.
That's
They're all good. I think most of them buy from either IDI Core or LexisNexis, and it's not even worth trying to go to Lexis. They'll decline most of us. So they're really set up for like law practices and things like that.
So I had a probate sale once where the heir, he had mental issues and he was present at the time. But since the estate closed, there was another check issued and the attorney couldn't find him. She had to put it in an account until they could find him.
Yep. And so this, your question about skip tracing would probably be directly related to that. Do you know if the attorney had LexisNexis?
I'm not sure what she had, but she tried to look for him, but he became homeless. So
yeah. Not every attorney, not every law firm. I mean, we like to think that if you're an attorney, you know how to find somebody. That's not always the case. So I would definitely, when I talk to an attorney like that, I would just kind of ask what skip tracing software are you using? And if they go, what's skip tracing? then you might want to step in and start doing it with them. And Garlinda, I don't know if Forewarn is free in your MLS or not. My wife uses it all the time. I don't use Forewarn because I would rather pay for something that I can get for free. All right, cool.
Thank you.
Any other questions, guys? Thank you so
Bruce,
much.
I shouldn't have said free. I meant I didn't know we had access to it. That's probably what I meant to say.
Yeah, I don't know. I don't know. I know everybody keeps telling me that I need to go check Forewarn out. Most MLSs are setting it up, and most of the time it is free in a lot of MLSs. It's just I'm in the habit of using things that I get to pay for. So I don't know what's wrong with me. I probably ought to start using the tools that I have and I don't have to pay for. All right. Anything else, guys? Anything else? No?
Hey, before you go, Bruce.
Go for it.
Oh, I was hoping I wasn't on. I'm not on mute.
No.
Hey, next week, guys, I'll go over if you want. I'm remodeling a little apartment. I'll go over the cost and what I made an offer on, and what it costs exactly to fix it up and have it on the market. So you guys get an offer how I get to an offer price with all the cost of hard money, and then actually selling it. If you
Amazing. Oh yeah, I wanted you to do that today.
I did too, but I just ran into a little delay. I don't have the photos, so I figured next week would be a really good example to show
Good.
the before and after.
Love it. So you guys don't
Yeah.
miss next week. You get to see a real live deal.
Oh, looking forward to that. Thank you.
Yeah. We'll stay as long as we need to go over every detail, how I get to the numbers. And I'll share my Excel sheet with y'all. And it's real simple. It's just a couple formulas.
Okay.
Oh,
Good.
you want to?
Well, David, appreciate it. We'll look forward to seeing next week. And everybody that's here now or missed, come back next week and you'll get to see that and ask any questions that you guys have. If you're brand new in probate, don't let this run you off. It seems like every 5 or 6 weeks, we talk about a lot of unusual deals. It just kind of pops up in waves. Not all probates are weird situations and weird deals. You're not always having to hunt down people that don't have a house, and you're not dealing with deceased people that are supposed to represent the estates. And yes, that stuff does happen, but it's not as common as it might have sounded today. But it does happen. So you need to know how to problem solve in this space. But it's not a hard business for those that might have gotten a little nervous. All right.
Really, those are the golden nuggets, aren't they, Bruce?
They are the golden nuggets. Yeah, because nobody else really wants those. And if you can solve, you're going to be the only person that's helping them.
Right. Yes,
Or
I love
buying
that.
for the business. Yes. Okay. Appreciate. Oh, Garlinda, there we go.
Sorry, just one last question about the attorney. So when the gentleman was given the advice about, given the recommendation to call the attorney, will they sometimes bill at closing, or do they expect to get paid up front, or it just depends on which attorney you go to?
It depends on which attorney. It's interesting because the attorneys that I had a conversation with this past week, a lot of them are starting to open probate departments. A lot of them are estate planning attorneys and not estate administration or probate attorneys. And I had 3 attorneys that were estate planning without administration and probate departments that all told me that they were opening probate departments. And it's interesting because each one of them said everybody's getting out, all the attorneys are getting out of probate, so we're getting in. And it was kind of funny because I didn't want to be like, well, I just talked to 5 other people who are all getting in. I didn't want to say that, but it's weird because so many of these estate planning places that kind of advertise and promote their practice as estate planning only are starting to do probate. Out of the 3 that told me that they were going to start opening probate departments, 2 of them already had a hire and they just hadn't formally announced that they were in probate, and one of them hadn't hired yet. We're still hiring. And the all of them referred me to other attorneys. So those conversations were extremely beneficial with referrals to another attorney. And how easy is that attorney call when you can say, hey, your colleague over here told me to call you. And I found an attorney that does consultations this week and basically just sits down as a probate person and will give you an hour-long consultation for a fee, and then says, if you want to hire me, this is what it is. But if you don't want to hire me, you just paid me $300 and I gave you all the steps that you need to take, which is phenomenal for a lot of families. I didn't find anyone that charges at closing, but I know that there are attorneys out there that only do a pay at closing. So depends on the firm. All right. Appreciate everybody being here, and we'll see you all next week for a riveting conversation with Dave.
Thank you, Bruce.
Thank you.
Thank you, Bruce. Next week.
Before we go, hold on. I've got another minute, and Tara's hand just went up. So what do you got? Are you still with? Can you hear me? You're on mute if you can hear me.
Okay, can you hear me?
Yeah.
Okay, I'm sorry I came here late. Are we allowed to ask questions about transactions, or is this only for prospecting?
Sure. Yeah. Transactions.
Okay. So I don't actually prospect for probate leads, but I wholesale and I flip, and almost all of them end up being probate because I'm mailing to people who've owned for 10 years or more. And what happens is their mail gets routed to their personal representative and they call me. And so I wholesaled a deal, and it was an assignable wholesale contract that the personal representative, who, as I understand it, had authorization from the probate court to sell, but there were other heirs involved. It was an assignable contract, and I assigned it, and it closed with the title company and title insurance and everything. And then I JV'd the flip with who I wholesaled it to. I wholesaled it for $0. And it's 3 months later. We're getting ready to close, and the buyer's title company, because here in Oklahoma, each side gets their own title company, and the title companies needlessly coordinate with each other. The buyer's title company is saying that they will not insure the title because the 239, which is the probate sale paperwork in Oklahoma, as far as I know, because I really I'm not as informed about probate as I should be. It was done as an authorization to sell to me for a set price, but the contract was assignable. It was and or assigns in the contract. And so now they're saying that the whole file needs to go back through probate, be reapproved by a judge, and no one can get a hold of the original probate attorney of whom I had no contact with. And I'm just wondering obviously, what should I do differently next time? And also, who dropped the ball here? Do you have any insight? I might not have enough information for you to have insight, but
Let's go over that one more time. Just say it one more time. I'm sorry.
Okay. I wholesaled. I got under contract with the personal representative in a probate, for a house that was in probate. And I wholesaled it. I assigned the contract to my friend, and for the same amount. So I assigned it, but didn't. I don't know if that matters, but I didn't have a wholesale fee. Right. It closed with the title company, with title insurance and everything. Then we flipped it together and we didn't list it, but we sold it off market to a buyer, a retail buyer. And their title company is now saying that there's chain of title issues because sorry?
Go back to the original title company. That's just the title company problem.
Yeah, no,
that's what I thought.
Okay, so in Oklahoma, I don't think it's like this in other states. In Oklahoma,
you're in Oklahoma. Oh,
yeah, it's so. No comment on that. Each party has their own title company, and we had originally been under contract to just hey, this title company just closed this three months ago. Let's just both stay with this title company, and originally that was fine. But then, a day later, this buyer's parents wanted them to
close at some other title company. So then we're into this situation where the buyer has their title company and we have our title company. My title company is standing by everything. They said we did everything correctly. But I feel like it's this title company not understanding the nature of an assignable contract.
It is. You should have never mentioned the assignment. That doesn't have nothing to do with.
No, we did not mention we didn't mention the assignment. They found that they are finding in their minds, they're finding discrepancy in the chain of title based on, well, we have what's called abstracts.
Someone said something along the way that caused them not to want to insure it. They don't want to insure it.
Well, what they're saying,
you're going to terminate this deal and go to another title company and start over.
Hold on.
Yeah.
Yeah, they are not wanting to insure it. That is true. But no one mentioned the assignment. What has caused them to be rankled is that the probate authorization of sale from the court has my name on it. So they saw that. And then they saw that it closed with my friend, and that now my friend is the one trying to sell it. And so no one mentioned the assignment of title, and maybe if they had, we wouldn't be in this position, but they're saying that there is a chain of title discrepancy because the probate paperwork at the county level has my name on it, and this is making them have all kind of heartburn. And so, and also they won't switch, the buyer won't switch title companies because they have some kind of ultimate faith in this title company. But I would just, they'll
send them an extension for an extra $5,000, non-refundable, and tell them that you'll go through the year process of recessing the whole title.
Is it a year process to because they were talking about doing a nunc?
It could be 2 years.
They were talking about doing it, but they were talking about doing a nunc pro tunc, which is where as far as I could tell, you go and you edit the record, and they're wanting to edit it saying that the court authorized him to sell to anyone, and that way. So I don't know. And then to make it worse, we obviously have a renovation loan on this that we're having to pay on. And in Oklahoma, if you have title issues, both parties are bound to stay in the transaction for 30 days to try to cure the title issues. Mm-hmm. And I'm just wondering is this even going to be curable in 30 days? Because if not, I really want to try to sweet talk the buyer into just terminating. But
yeah. It's absolutely curable. Now, first off, as I'm assuming that your title company probably owns the title insurance, and I'm saying that mostly because I'm in a attorney state, and the attorneys can switch title. So if one title company says title insurance company says I'm not going to do this, they can immediately just go switch title insurance. They might have some heartburn over it because maybe they make some money off title insurance, but they can go switch. And I've forced attorneys to switch title insurance. So it doesn't mean that the attorney, or in this case, potentially the title company, doesn't still represent the buyer.
Right.
It just means that you're kind of forcing your policy that has already been underwritten into their process. And that's what I would try to do.
Okay.
To say, look, we have marketable title.
Yeah.
And it is, and you can piggyback on this, and you don't have to switch your representation.
Okay, so I just need to ask them to go with it because, and I've been in real estate for a while, but I've never truly taken the time to understand how title and title insurance and escrow all kind of fit together. But it seems that the attorney for the title company is not willing to underwrite it. Like the commitment to title came back with that as an exception, and that would have to be that the record would need to be edited. In that case, would I still go back to them and say, you need to find a different?
Well, you should be, and you have your own representation on the deal. Is that correct?
Yeah, I have my own title company, which is the title company that closed it 3 months ago.
Yep. And they
said that they would close. They're like, have the buyer come over here, and we'll close it today. This is not anything. Are they
There's
right?
an
I
attorney.
can't tell who's screwing me around.
You have an attorney with your title company that you deal with?
They have an attorney. I don't have access to that attorney. I
Have
hear,
their attorney call the other title company's attorney. So you're dealing with title companies,
yeah,
and I don't do a lot with title. We can have title companies involved. It's just not. It doesn't really happen here. This should be an attorney to attorney conversation, in my opinion.
right. And that's happening today. They're doing the attorney to attorney
That'll
thing.
probably solve a lot.
Okay.
Yeah, that's
Okay.
probably going to help you.
So first, can I just ask, in general, when you have when you're under contract with a personal representative in a probate sale and you have an assignable contract that you intend to assign, do you need to do any other kind of due diligence? Does the court need to be involved with the person you assign it to? Did I drop the ball?
No, you don't need to have your name on the administration paperwork. That's not good.
No, I don't think you really did anything wrong.
Okay.
No, you didn't do anything. It's
Yeah.
definitely a title.
This is clearly just a misunderstanding in title. They're used to really clean, cut and dried processes, and not every probate's clean, cut and dried. I've had courts that have done really weird things. I've had courts put clients in jail for
Yeah.
not obstruction, but put them in jail for contempt of court because they were in short sale process before. Like sometimes courts and attorneys and title companies just don't understand, and that's where having two attorneys get involved in a conversation is probably the best bet. I would the attorneys getting together for the two title companies will probably get it cleared up. That's my guess.
Okay, so it just seems likely that the new buyer's title company is just not familiar with assignable contracts.
Yep. Seems.
Yeah. And then,
Okay.
and try to control it on your side if you have a hard money loan pending. Just try your best to have the title company, even if you have to pay the title cost to close it.
Yeah.
Mm-hmm.
Yeah, it's not hard money, but it's still money. It's still
it's still
a bank loan.
Yeah.
Yeah.
I know the buyer has a right to, sorry, Bruce, but I know the buyer has the right to pick their own title company and blah, 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 blah. But if you're closing deals back to back like this, it's nice to go ahead and pay the small title fee on these deals and make sure that you could get the title company, the one that you're familiar with working with.
Yeah.
Mm-hmm.
Yeah. Okay. Awesome. Thank you guys.
Thank you. Appreciate it.
Bye.
And Helena, I would, but I've got a call coming up in just a second, and I got to go. I apologize.
I'll help Helena if you want to keep it going.
Well, I just wanted to ask Tara, how did she market those people in the first place? You said you go back.
No, yeah, I'll tell you exactly what I do. I send enveloped mail, DIY, so I just put a real stamp on it. I send offer letters to people who have owned for more than 10 years that fit my buy box, which is first time home buyer, in the school districts that I like to sell in. And out of all the flips I've done, like I would say maybe 75% of them were either inherited or probate, because the mail, the court records have not updated yet. And so the public records are still showing the deceased person as the owner, and all of their mail is getting opened by the heir or the personal representative. And then they call me.
Okay. Thank you for sharing.
Yeah.
On average, and I got to ask this, and then I'm going to be late for a call. Okay. In general, how far after the deceased has passed away are your typical responses? Like just
man, old. Over 5 years for all of them, probably. And I don't know what that's about. No, that's not true. There's been a few I haven't closed. I still got the appointment, but they went with someone higher. And those people were maybe within a year. But I haven't closed any of those because I think that you have to. I mean, I know what I did wrong. They're like, we're not quite ready to sell yet. Why don't you call? We're wanting to sell in March, and it will be like 2 months away. And I'll call them a month later, and they've sold to someone else. And so I have to change my
Happens all the time.
I have to change my how I go about that conversation because they clearly are ready to sell and they're just not feeling ready to sell. And I did kind of say like, well, I'd love to just come see it and whatever, give you an opinion, whatever. But I think that there's a better, I just prospected them poorly with the conversation.
Yeah. Yep. Probably not poorly, but there should be some adjustments there. And we'll talk about some adjustments next week.
Okay. Thank you guys.
Greatly
looking forward to
appreciate
that
everybody being here. Yeah. Good. Okay. Thank you guys.
Bye.
See you. Bye.
Thanks, Bruce. Bye.